application to intervene as a further applicant in the matter and to seek in his own right the review and setting aside of the Public Protector's report. There was no opposition to this intervention application. Between 30 September and 2 October, the application was argued in the High Court. The High Court's judgment was handed down in December, in which the Public Protector's report was reviewed and set aside with costs on an attorney-client scale. I will come back to the judgment in a few moments because there were cost orders that went in favour of the Public Protector in respect of an interlocutory application, and then there was cost orders in respect of the applicants, lest I be told that I'm only doing one aspect of it. The Public Protector and Advocate Mkhwebane then launched leave to appeal the application in the High Court, which application was dismissed with cost. There was also a cross appeal that was also similarly dismissed. There was then a petition to the Supreme Court of Appeal by the Public Protector and Advocate Mkhwebane, and the petition was dismissed with cost by the Supreme Court of Appeal. These become important because at some point we're going to be asked the question of presenting to this committee legal costs. And whilst it's currently a work in progress, we will spend some time explaining to the committee how legal costs operate. The Public Protector and Advocate Mkhwebane then, pursuant to this petition, dismissal of the petition to the Appeal Court, launched a reconsideration in terms of the rules to the Chief Justice. This was similarly dismissed. Subsequent to the dismissal by the SCA of this application, they petitioned the Constitutional Court. The Constitutional Court dismissed this petition with costs. So that's case number one, right? The next case, and we'll just briefly go to it because just to refresh your memory, we went through this case in some aspects. We dealt with Part A and we went through the judgment of Procedural J in some expense, to some degree in relation to the SARS unit matter. I didn't take you in detail in relation to the second judgment, although we dealt with certain aspects of it, and we're going to touch on certain paragraphs in this judgment which Mr. Pillay would like to pertinently draw to this committee's attention. Now, in this instance, this is where the classified report of the office of the that was prepared by the Office of the Inspector General comes back into play, and we've spent quite a bit of time on that, right? And what we will then see, if you go further on, the part that I'm going to be dealing with, go down. Similarly, Mr. Pillay had deposed on the 29th of September 2019 to an affidavit in support of the Minister's interlocutory application, and as did Mr. van Lachenberg. In August, Mr. Pillay launched an application to intervene as a further affidavit and to review and set aside the Public Protector's report. Again, his intervention wasn't opposed. In August, there was an application for leave to appeal to the Constitutional Court in respect of the Part A of the application which we dealt with. Let's go down on this, right? I don't want to be dealing with Part A of the application today. I'm dealing with Part B of the application. So what transpires in Part B of the application after Part A had been dismissed by the Constitutional Court in May 2020 is that the High Court hears Part B of the application in August 2020 and the hand-down judgment in respect of that. And it's this judgment in which there is orders made against Advocate Mkhwebane in her personal capacity, and there are a range of other orders which I will also come to, right? If we go down, just to take this to its transgression, there's the various levels of appeal. In this case, the appeal is still before the Constitutional Court and no judgment has yet been handed down. So it's an important distinction to be made in that whilst in respect of case 36099, the proceedings are finished. in respect of the second case, there is still one judgment outstanding before the Constitutional Court, right? Now, I am not going to take you through all Mr. Pillay's affidavits. Put the number 1 in bundle E, right? But I am going to highlight the affidavits, and we will see that the initial application in 3609, as I've pointed out, there is a founding affidavit at number, yeah, that's the right one. Yeah, go for it. And the reason I'm taking you through the index is because we mustn't lose sight of the fact that it is these affidavits that serve before the courts and which the judgment is premised on. And so at some point, and these affidavits have been commissioned, they constitute evidence, we will need to look at some of these affidavits, right? So the case starts with the founding affidavit at number 5 of Minister Godam, go down. Right, there's lots of annexures. We then come to item number 54. You will see that there's an affidavit from Mr. Pillay, and at 58 you will see Advocate Mkhwebane's response to that affidavit. You will then go to 66 and 67. You will see that there's the replying affidavit of Minister Godam, Mr. Pillay, served before the court. And if we go down, just go to 81, 82, we'll see the Rule 53 record and supplementary record, which is filed at court by the Public Protector. And if we then go down to 81, we will see the application for leave to appeal made to the court itself and the application for leave to cross appeal at 91 and 92, 98. If we then go further down at 101, we will see the affidavits filed at the Supreme Court of Appeal and the answering affidavits in both the appeal and cross appeal, that both was refused, right? And if we go down to 114, 115, we see the respective responses to it, as well as the application to the Chief Justice to which I referred you to. And then if we go, I think at this point I probably lost steam at highlighting, but let's go down at 126. We will then see, like I said, the application to the Chief Justice, and at 139, again, you see the affidavit of Mr. Pillay in that process. Then we come to 143, which is the application for leave to appeal before the Constitutional Court, which was brought by Advocate Mkhwebane, and the answering affidavit, well, let me not, and then the answering affidavit by Mr. Pillay in that regard, together with that. Right, so that's the one case index, and if we go to the other case index, we will see, and you'll find that at number 7, the first item. Let me just, yes. Thank you. Right, at number 2, you see the opening affidavits. And then there's lots of annexures. At number 35, you will see the Advocate Mkhwebane's answering papers. And at 41, I just want to draw this distinction to you. You will see Mr. Pillay's affidavit then as the 8th respondent. Right. At 55, you'll see that there's an intervention by the EFF together with an affidavit from Mr. Malema, and he attaches certain documents thereto. At 58 and 59, you'll then see a replying affidavit from Mr. Gordam at 61. At 69, you will see what is recorded as the first and second respondents answering affidavit to the 8th respondent's affidavit. That is Advocate Mkhwebane as the public protectors. The public protector is the first respondent and Advocate Mkhwebane is the second respondent. They talk about the 8th respondent or the second applicant, it will be Mr. Pillay. And you see that from 74, he puts in the affidavit of his intervention application. And at 86, attached to that is the affidavit which Mr. van Lochenberg spoke to as to what he filed, and which was before you when he gave evidence at 86. All right. So there is numerous other affidavits by the various parties. I do want to draw, I don't want to waste time taking you through each one of them, but the point I'm trying to make is that there are several affidavits filed by both Mr. Pillay, and to which Advocate Mkhwebane responds, or which is filed by Advocate Mkhwebane, to which Mr. Pillay responds. And it is those affidavits which informs the judgments. And so I'm briefly going to take you to the judgment, which is attached to Mr. Pillay's affidavit. Right, let's just see if it's one or two. Mr. Pillay's affidavit is to be found at bundle D. And it will be what's annexed to VP1, the judgment of 3609.
Chairperson?
Yes, Advocate Mpofu, just pause Advocate Bauer.
Thank you, Chair. Sorry, I've had my hand up, but you probably didn't see it.
My apology.
No problem. Thank you, Chair. Good morning again, Chairperson. Yeah, I just want, if I just didn't want to interrupt my learned friend, I want to place one or two things on the record and raise an issue for the sake of formality for your ruling. The first is that in fact, it's appropriate that I do this now after you've seen the scope, in the thousands and thousands of pages that we're going to be dealing with. The first issue pertains to the issue of relevance once again. And it is in the context that of what Advocate Bauer has correctly pointed out, that as far as the, let's call it the retirement case is concerned, that one has run its course and it has been concluded. But as far as the rogue unit matter is concerned, it's still pending before the Constitutional Court. You remember we went through this before Mr. van Lochenberg's testimony. We just want to place on record again, as far as we're concerned, the rogue unit matter, therefore, is still in the court pipeline, and the retirement matter, as far as we're concerned, is completely irrelevant to what is happening here. Or, as I did yesterday, I'd like to invite the evidence leaders to tell us in respect of which part of the motion the retirement issue is being raised. And subject to your ruling, well, I think we know what your ruling will be, but I have to do what
you don't know. You don't know.
I know. Well, I have an idea, Chair, but
Please.
Maybe you're right. I don't know for sure.
I wouldn't want to be anticipated.
Okay, no, apologies, Chair. But subject, if my hunch is correct, then the the next question then comes in, which is the sheer extent, Chairperson, of both, assuming your ruling is that you're going to allow them to deal with both matters, then the sheer extent of what we have to deal with means that I can tell you now, we're not going to finish with this witness today or tomorrow. Well, I know tomorrow is a Saturday, but as I said, we're ready to continue wire. But the on a serious note, Chair, I think let me make two submissions. One is that your allocation of time is in any event unfair, because the rule of thumb is that cross-examination takes 2 times or even 3 times of what the evidence in chief would be. So your allocation of equal time for the evidence in chief and the cross-examination is just inherently unfair here. But be that as it may, in this particular case, there is just no ways that we can cross-examine on these thousands of pages in the time allocated. So I'm almost, as I say, 100% sure that we're not going to finish with this witness, even if we had an extra day, particularly if I'm right about what your ruling will be on relevance. Now, Chair, I'm raising that upfront so that firstly, so that we get the ruling, but also you don't have to, on the question of time, you don't have to deal with it immediately. It's just an issue that I'm raising because it's clear. I think anyone who has been involved in this process by now will know that if we could take a full day with a witness like Mr. Mahlangu and finish at 8 p.m., who has a 15-page affidavit, without annexures even, then, if we have 6,000 pages to wade through and 100 judgments that Ms. Bauer has spoken about, and the Constitutional Court and affidavits, answering affidavits, intervening affidavits, 2 public protectors' reports, the rogue unit, this and that. To think that is going to be done in a matter of a few hours, if there is justice, is just completely unrealistic. Thank you, Chair. I just wanted to put those 2 things on the record and to ask for a ruling on the first one. Or the other side, maybe the Ms. Bauer can explain the relevance. Thank you. Thank you.
Thank you. I am going to recognize her so that she can speak to us about whether what you refer to. She wants today that we deal with a mountain of issues. Advocate Bauer?
Chair, the point of having taken you through that exercise was to say to you, those have all been considered by the court.
Let's just pause, Advocate Bauer. Honorable Kevin Milam, you are disturbing us. Please mute. Thank you. Advocate Bauer, you were indicating something?
The point of taking you through those affidavits was not for purposes of leading the evidence on those affidavits. The point of taking you through those affidavits was to show to you there are affidavits on the one hand by the parties who brought the applications. The public protector had an opportunity to answer the allegations in those papers before the court. Those were the factual and legal submissions contained in those affidavits and the arguments which informs the judgment before you. And that is the framework which served before the court, which informs the judgment. And it's those judgments which have made findings against the public protector in some instances and findings for the public protector in respect of certain arguments against her, based on huge amounts of papers which served before the court. I certainly don't intend taking Mr. Pillay to those affidavits today, nor do I intend taking you to the affidavits of Advocate Mkhwebane today. So we are not going to be leading evidence and cross-examining. Well, I can't say what Mr. Mpofu is going to be doing, but I'm certainly not going to be leading you on the evidence. They are judgments. They are judgments that have made findings against the public protector, and it's those judgments which have informed this process. There are specific judgments before this inquiry, and Mr. Pillay is one of the people who, pursuant to a call from this committee to provide evidence to this committee relevant to the motion before this committee, who had come forward in that public submission process and said, I wish to place an affidavit before this committee and in which I wish to make submissions for it. And in order to sketch the context of that, there are two judgments which underlies Mr. Pillay's basis for submissions, and they are attached to his affidavit in doing that. And those are the judgments relating to the SARS unit and the judgment relating to his pension. I'm certainly not going to spend hours on dealing with the pension. I'm going to highlight the salient parts of the judgment in the course of taking Mr. Pillay through his evidence and his affidavit to do that.
So by and large, you're placing these issues for record in this committee.
Yes. In order for the committee, we've gone through various witnesses, and each of them has various cases. There are thousands of pages in affidavits underlying the CX judgment. There are thousands of pages of affidavits underlying the Vrede Dairy. And the committee needs to have an understanding that these judgments don't get plucked out of the air. They are informed by affidavits which the parties place before court, which constitutes the evidence which informs the judgments before this court, before that court, in various instances. And there are affidavits at various levels of those courts. But the judgments which come out has got certain orders and certain ratios that are binding. And whilst Mr. Mpofu and I may disagree on the extent to which you rely on those judgments, that's an issue that has to be argued at some point, in which Mr. Mpofu will certainly tell, I'm sure, the committee where he disagrees with the judgment. My only point that I sought to make to the committee this morning is that Mr. Pillay has filed numerous affidavits. On the basis of those affidavits and Advocate Mkhwebane's answer to those affidavits, or Mr. Pillay's answer to Advocate Mkhwebane's affidavit, is what informs the judgments which is attached to his affidavit, which is before you today.
Okay. Thank you for that clarity. Advocate Mpofu?
Thank you, Chair. Okay, just briefly in reply, yeah, I mean, I'm not entering that space about whether the committee can rely on judgments or not. You know what our views are on that. I've raised two issues. One has not been answered, which is relevance. So I'm assuming then there's no relevance. But as I say, I'm still confident of what the ruling will be. But the
relevance on the pension one.
Yes,
is that what you asked?
That's the issue I raised, which has not been answered. But as I say, anyway, look, so I'm doing it for formality, because
no, I don't want you to do things for formality. Advocate Mpofu, just pause. I don't want you to do things for formality, because if you do that, it would mean that you have got a committee and a chairperson that has got a completely predetermined mind on any issue, and I don't want. Yeah, no, it would not be correct that I'm projected that way. Yeah, no.
Thank you.
Maybe
No. We're open. We're ready to be proven wrong. We have an open mind, as they say in the Weekly Mail case. No, Chair, I'm not even there on the predetermined outcome. I'm simply saying I've raised that issue. It has not been raised, but the more pertinent issue, Chair, that I'm raising is this. I appreciate what Advocate Power is saying, and she will tell you, I'm the person who proposed that we start early today. It was my suggestion that we start at 9 because this was all in aid of trying to see if it's possible to finish Mr. Pillay, because I know he's overseas and all that. But I'm telling you that I'm not prepared, or rather the public protector is not prepared to accommodate to the extent of unfairness. And I'm simply saying on what has been put to you, the scoping that has been put to you, and Advocate Power is right, I have no control whatever. She might want to ask one question, that's her prerogative. But as far as the cross-examination is concerned, because when she puts those issues, she didn't put them there just for decoration. She put them there because they have relevance to some of the issues that she wants to argue at the end. And I'm simply saying, Chair, that on that basis, it's I don't want to be dramatic, but it's impossible that this witness will finish today. And I'm telling you that as the Chair so that you keep that at the back of your mind, because we're not going to be bulldozed into asking 3 or 4 questions so that we meet some predetermined timetable in this regard.
Yeah, that thank you. The timetable will be determined by the Chair. I'm firm on that, and when that time comes and there are problems, we'll always consider that. I have no problem with that. Advocate Bauer, just your last point on the relevance of the pension issue that which is in the affidavit.
It's dealt with in Mr. Pillay's affidavit, and unless I'm going to waste more minutes having this debate, Mr. Mpofo's already taken 15 of my minutes.
Okay.
Chair, I have to react to this, so I'm sorry.
Why
for the record, I'm sorry, Chair, just for the record. As I say, I'm not expecting miracles. So what, Chair, it's not an answer to say that somebody put something in their public reaction to the invitation. That just opens a whole new can of worms. Because what that means then, your version, Chair, of events is that you are guided by the motion. And you know our views about that. But even now we are going even beyond the motion. Now you are telling us that you are going to also include as relevant to the motion things that came 2 months ago, which never went through past the independent panel report for prima facie filtering, even at a level of pretense. So if that is how this committee is going to run things, then we must be told. Because you can't be told that something is relevant, which was not part of the motion. Your own directives say that something is relevant if it talks to the motion. And I'm simply asking a simple question. Which part of the motion is the pension issue going to talk to? I have no answer to that, except to say that it's part of some public submissions, which we were not consulted about. Nobody told us that they were how to react. We asked whether this will form part of the evidence. I asked you specifically, Chair, in a letter which we wrote to you in May. And we were assured that because we said if there's going to be new evidence that comes as a result of the public inputs, then we need to have out the alteram partem in respect of that. And your response was, no, that's just for public participation, I'm paraphrasing or whatever, but it's not part of the motion. But now we're told that it is.
Okay.
Yeah. So that's what, as I say, I'm putting it on the, I know what's going to happen, but I'm just putting it so that I'm never accused one day that we were acquiescing in this unlawful and illegal procedure.
No, thank you, Advocate Mbofo. It just to make the point, yesterday you would have raised certain objections and they related to certain matters on a different matter, and today you are within your own right raising some objection about the issue of relevance on a different issue. So there is never a one-size-fits-all kind of a ruling. There will never be a one-size-fits-all ruling from the chair. And so I wouldn't want you to invoke any raising issues just for formality's sake, because we're not there in the way we interact, in the way we run this process. Two things, because I think you, in your credit, you would have raised these issues up front. We differed in terms of our own directives and terms of reference, but differing with you does not mean we're going to bulldoze our way as a committee. As part of the fairness, we've got to listen to the issues that you're raising. As I would have, just two things, as I would have indicated yesterday, let us, in terms of 8.2, see as this committee what the issue of the pension in terms of its relevance would be. And in that sense, I would rule on the provisional determination on the issue, as we also did yesterday, because I think the committee has got to make that assessment and apply its mind, having had what evidence would be laid here. And when we do that, it is not ignoring the points you're raising. And I hope you take it in that spirit. The last point, I am going to ask that I think for the coming witnesses that, as suggested yesterday, both yourself and the evidence leaders, some of these matters must be attended to before. They're not just raised when we start the hearing, because affidavits, the fact that we have a list of witnesses is known by both teams. And both teams know what this witness is going to be focusing on. And I'm asking that be attended to by the two teams, and where there are challenges, I think as a chair, I would come in, so it doesn't come across that one of you is taken by surprise or one of the teams is just ignored in terms of the issues that you are raising. So for us to cure that, I think it would be proper that we, and it will be better than when you come in and say, we have discussed this, we don't agree, and I'm placing on record, and I would accept that at that particular point. So I would make that request as we go forward. Thank you, Advocate Mpofu. May we proceed, Advocate Bauer?
Thank you.
Just before we proceed, there's Honorable Melder.
Yes, thank you, Honorable Chairperson. My apology. When Advocate Mpofu just now made his point, he said he do not want to be blamed later that he said this and that and the other because while participating in this illegal and unlawful procedure. Did I hear him correctly?
Yes.
My problem is this. He says it is. Okay, fine. So the point I'm making is that I want Advocate Mpofu to make up his mind. You can't have it both ways, sir. When we started with these proceedings, you said right from the beginning on day one that you respect this procedure, you respect Parliament, and you are participating voluntarily in this procedure. When you put your arguments in front of the Western Cape Provincial Court, the High Court, you also argued that this procedure is unlawful and illegal. Do I understand it correctly that your view is that this procedure is unlawful and illegal, but you are here under protest, or what is your position? You can't have it both ways. And then I just want to say from our side, as my perspective, this procedure is absolutely legal and it's absolutely lawful in terms of the law of the country, in terms of the resolution taken by Parliament, and we cannot accept this kind of slur being thrown at this committee on a Friday morning. Thank you, Chairperson.
Chairperson?
Thank you, Honorable Melder. I'm wanting to proceed. I'll acknowledge you, Advocate Mpofu.
Yeah, I'll be very brief, Chair. No, I think the member is out of order and they should rule him as such. I've said from day one here that we are participating in this process, but our view is that it is illegal and irrational, and I spent half a day explaining why, and it was debated by this committee, and our presence here was accepted on that basis. So if Honorable Mulder is a judge and he wants to tell us that it's legal, that's his privilege. But I'm just telling you our version, and I know that there was a version, a counter version by other parties in the court case. So it's unhelpful for me to hear Mr. Mulder's judgment on the pending judgment of the High Court. I'm simply telling you where we stand on the issue of legality, and it's not to say something is illegal is not disrespect. It's if it's illegal, it's illegal, and I'm here. So we are here to participate, and but we have a view about the process, and
sure.
Nobody to bully us into their own view.
All right.
Thank you.
Thank you. Thank you, Advocate Mpofu. As I proceed to Advocate Bauer, just to re-emphasize the point I would have said all along, that this Section 194 committee that I'm chairing, I'm not presiding over an unconstitutional, unlawful. I think we respect the view that you share, which you placed and ventilated in court, and there is no court that would have declared our process unlawful and unconstitutional. And so I think,
and no court that has declared it constitutional either.
No, don't interfere with the chairperson.
Oh, I'm sorry, Chair. Yeah.
Yes.
I apologize.
Thank you. So I therefore want to proceed. Advocate Bauer?
Yes. So if we can now turn to Mr. Pillay, who's been waiting patiently for his evidence to be read. Mr. Pillay, are you there?
Yes, Advocate. Yes, I'm here.
Now you deposed to an affidavit which one finds in our bundle D at record page 1543, and it was pursuant to the process followed by the committee asking for public submissions, correct?
Correct.
Sorry, Mr. Pillay, you submitted your affidavit following the public submission process. Can you hear me?
Yes, ma'am. Yes, I did.
Yes. Okay. And attached to that affidavit are the two judgments, the one relating to the pension matter and the one relating to two issues primarily in the other matter. One, the SARS unit, and the issue of your qualifications. Correct?
Correct, Mr. Chair.
The third annexure relates to another report that had been issued by the public protector in relation to an entirely different matter.
Yes.
Correct?
Correct.
Right. Now, if one then turns to the matter dealing with the SARS unit, paragraph 128 of the judgment, and that would be judgment, which would be two, the second.
Please repeat the paragraph.
128 of the judgment.
Yeah.
Right. It indicates that you had previously been employed at SARS. You had various senior positions within SARS from 1999 to May 2015 when you left its employ. It then details those positions to be the Chief Manager, Chief Investigations, Chief Officer Enforcement, Chief Officer Strategy and Enablement, and Deputy Commissioner, as well as Acting Commissioner. And that the SARS unit had the unit, the HRIO unit, formerly known as the SPU unit and renamed the NRG unit, had reported directly to you from inception in July 2007 to March 2008, correct?
Correct, Mr. Chair.
Right. And then at paragraph 5 of your statement, you point out that you are investigated by Advocate Mkhwebane in a capacity as the incumbent public protector and found guilty by maladministration and misconduct in 3 matters on which she published reports. 2 of those reports, the evidence that you had provided to her was entirely ignored or irrationally dismissed. And with regard to the 3rd report, which was, I think it was published in May 2022, you had not even been informed by the public protector that you were implicated in an investigation by her and that she intended making adverse findings. That's in paragraph 5 of your affidavit, correct?
That's correct.
Okay, and that is the context in which you have come to give evidence before the committee today.
That's correct.
You then in your affidavit, sorry, so we'll call the latter report the 3rd report. And if we can just maybe sorry, Mr. Kudam, if you can just bear with me for a second. I mean, sorry, Mr. Pillay. I'm just, right. In respect of this 3rd report to which you have referred in your affidavit at paragraph 9.1, you've indicated that in 9.1 that there were serious adverse findings made against you and remedial action in the form of a criminal investigation. And did you receive any notice in respect of this report?
I received no notice.
Any invitation to attend an interview?
No.
You then caused court papers to be issued on the 25th of May 2022 asking for the report to be reviewed and set aside, correct?
Correct.
Okay. So now let me take you to the judgment which is next to your affidavit marked VP1, which is the judgment relating to your pension, let's call it the pension matter. And one sees from the judgment and the report that it emanated from an anonymous complaint relating back to matters as far back as 2010. Is that correct?
That is correct.
And that the matter related to what was in essence the minister's approval of a recommendation by the then Commissioner of SARS approving your early retirement with full pension benefits and your then retention as on a fixed term contract thereafter.
That is correct.
One sees that from paragraph 8 of the judgment. And the judgment essentially finds that The judgment essentially in the course of its ratio finds that the public protector had, in the first instance, not applied Section 6(9) of the Public Protectors Act correctly and did not have jurisdiction to deal with the matter. It then finds in favor of the public protector that on certain in limini points, that certain averments that occurred in Mr. Godam's affidavit be struck out. And then the court goes on and it looks at the various grounds of review, and it finds that there are merit in a number of the grounds of review, and it essentially sets the report aside. Would that be an accurate summary of the gist of the court judgment?
Yes, it is.
Right. In paragraph 11 of the judgment, it sets out the remedial action, the findings and the remedial action that had been ordered by the public protector. And in this matter, were you served with a subpoena, and did you appear before the public protector at all?
Yes, I did.
Right. And by the time this matter got heard, the matter in relation to the SARS unit had already been handed down, correct?
Correct.
And the full bench in that matter had dealt with the ambit of Section 6(9) and the question of special circumstances. Correct?
Correct.
And if one looks at paragraph 41 of the judgment, in terms of the background to it, the issues that the court said that occupied its attention revolved around a point in time at which the special circumstances must exist and be judged for. In fact, it was common cause that the complaint had emerged in 2010 and that the 2-year-old criteria had already passed. And so what the court was debating, or the debate around court, was at which stage of the process before the public protector was it necessary for special circumstances to exist. And I won't take you through the law on this issue, but one can see from paragraph 51 of the judgment that the upshot was that the special circumstances required in Section 6(9) of the Public Protector Act must be in existence at the time the Public Protector exercises a power to permit the entertainment of a complaint which is more than 2 years old. She must use these factors when she exercises her discretion whether or not to permit. For the Public Protector to exercise her discretion properly at the time of such exercise, she must have all the facts before her. It does not avail her to say she remembered other reasons later on. And this was at the time in line with the established SCA dicta that reasons must be given at the time when a decision is taken, and also the then full bench decision that was given. Now, If one then goes in paragraph 54 and 55 of the judgment, one sees that it says the fact that the public protector dealt with this issue in this haphazard manner is an indication to us that she failed to understand fundamental jurisdictional requirement, or she simply ignored it from the very outset. It is also an indication that she does not know when to exercise her discretion in terms of the section. This leads to an inference that when the public protector commenced with the investigation in this complaint, there were no special circumstances in existence. Relying on GEMS, which binds this court, and the following on Gordon, where there are no special circumstances, the public protector lacks the necessary jurisdiction in terms of 6(9) of the Public Protector Act. And the court then concluded that based on section 6(9), the public protector had no jurisdiction in the matter, and it said in 56, our finding is dispositive of the entire matter, axiomatically the report which flows from the impugned decision that must be set aside. Correct?
Correct.
Right. But the court then goes further and, apart from the absence of jurisdiction, concludes that the report is fundamentally flawed and falls to be reviewed and set aside. And if one goes to paragraph 123 of the judgment, there were a number of grounds which were argued and which dealt with that. And I'm not going to take you through all of them, but what the court says is we are of the view that the errors of law committed by the public protector in coming to a decision and no findings is material, and so as we shall hereunder show. And they then deal with the said findings in detail to show that the public protector was wrong in law and that Minister Kodam's decision was perfectly lawful, and that there was a mistake in law which was material, rendering her findings irrational. And the court then deals with those in the course of its judgment in a number of paragraphs, dealing from paragraph 132, 33 onwards, and we won't necessarily deal with those in details, but in essence, it comes to the conclusion that the public protector's report was irrational. In that regard. Correct?
Correct.
Right. And the ratio is contained. The report also concluded, and if I take you to 215 and 16 of the judgment, the public protector had concluded that the payment of 1.258 million by SARS paying the penalty amounted to an irregular expenditure premised on the fact that Mr. Kodam had acted unlawfully in approving the full pension benefits, and the court had concluded that this happened by operation of law and required no approval by Minister Kodam at paragraph 115, 16, 17 and onwards, and it then set aside in paragraph 218 to 24 onwards, the remedial action is considered and set aside.
It is so.
That is so. But there was an added complaint by Minister Kodam in paragraph 224. Um, he raised the complaint that the public protector did not allow him an opportunity to make representations on the remedial action being ordered. Can we go down? And paragraph 20, sorry, it's 2026, the court records it was common cause that the public protector had not afforded Minister Godan a hearing on the remedial order she had made against him in section 7.9 notice that the public protector had sent. I think had you been given notice of any remedial action, Mr. Pillay?
No.
And the court then
Just try to get closer to the mic so that we can hear you properly, Mr. Pillay.
I was not given any notice.
Thank you. That's much better.
The remedial action.
Thank you. That's much better. Advocate Mpofu, I see your hand.
Yes, Chair. No, I was just taking advantage of your intervention. I've had my hand up and you're not recognizing me. I don't know. Maybe is it because my hand is black?
Well, you stated it's black, not me.
All right. Thank you, Chair. No, I wanted just to, for my notes, I wanted to check whether I correctly had Advocate Bauer when she referred to what she called the ratio of the decision.
So, Mr. Mpofu, we can have an argument later about.
No, I'm simply asking if I heard you correctly. I'm not arguing
yes,
anything.
Yes, you did.
Thank you.
Yes.
Thanks.
Okay, go ahead, Advocate Bauer. Thank you, Advocate Mpofu.
Thank you, sir.
Right. If you just give me a moment, Mr. Pillay. Mr. Mpofu's just assisted me in losing my train of thought. Just give me a second. Mr. Pillay, you were successful in opposing the appeals, and I'd already pointed out that in respect of the pension matter, the application before the public protector's application for leave to appeal before the Constitutional Court was dismissed with costs, correct?
That is correct.
Right. And this was after several courts had held that there was no reasonable prospects of success on appeal. Correct?
Yes, it is so.
Right. Now, I'm now going to take you specifically to the judgment dealing with the SARS unit under case number 48521, which would be the first annexure to your affidavit.
Yes.
If one goes to paragraph 133 of this judgment, sorry. court said in determining whether the public protector's findings were rational, it is important to ascertain what processes she followed in coming to the findings and what evidence was available to her when she made the findings. As a starting point, it is necessary to briefly deal with the complaints against Mr. Pillay as set out in the subpoena, which was delivered to Mr. Pillay by the public protector on 10th April 29, and the notice in terms of section 7.9 of the Public Protector Act. Now I'm at, excuse me just for a moment.
Chair, I think that's the wrong paragraph. I'm not following.
Come again, Honorable Aaron.
Advocate Bauer referred us to paragraph 133 of the judgment and then read something that is not in paragraph 133.
Sorry, we
Okay.
go to VP2. I said we were moving on to the judgment in relation to the SARS unit, and I didn't tell our operator that that was a separate judgment. My apologies. Yeah, and so it would go to paragraph 133. I apologize for doing this, but the operator is using a different version of the judgment that I am, so I can't give a easy page reference to do that. And effectively what I read earlier on was that Mr. Pillay had deposed 2 affidavits, one dated 23 April 2019 in response to the subpoena, and identified in the judgment as the first affidavit, and one dated 18 June 2019, which was the second affidavit. Is that that's recorded in the judgment? In paragraph 8 of your affidavit before this committee, you refer to the report on the investigation into allegations of violations of the Executive Code by Mr. Praveen Gordam, as well as allegations of maladministration, corruption, and improper conduct by SARS. This is the report that was issued on 5 July 2019, and which was the subject matter of this judgment, correct?
That is correct.
Right. Now, it was suggested to this committee that Minister Gordhan was the primary target of this report. Would you agree with that categorization of the report?
Comrade Chair, it is difficult for me to say exactly, but if I understand it, that the term came from an earlier discussion. I have always felt that there were bigger issues at play, and that it was actually the capture of SARS. And that is the reason why so much of pressure was brought to bear on us in SARS and many other people in the country. So I've never felt that I was a personal target. I don't know whether that answers the question. Thank you.
Mr. Pillay, if you go to paragraph 130 of the judgment, there were 5 adverse findings made against you by the public protector that is detailed in the judgment. Let's see, 130. And it's detailed in the judgment. You've right under separate headings. 1, that SARS under your guidance and management as General Manager, Enforcement and Risk, established an intelligence unit in violation of the South African intelligence prescripts. 2, that you were involved in a failure by SARS to follow proper procurement processes in the procurement of intelligence equipment, which the intelligence unit utilized for gathering intelligence. 3, that you were involved in a failure by SARS to follow proper recruitment processes in appointing employees who worked for the intelligence unit. 4, that you were involved in carrying out irregular and unlawful intelligence operations, and then it details those in that regard. And that 5, that you were appointed to the position of Deputy SARS Commissioner and subsequently a SARS Commissioner whilst you did not possess the necessary qualifications for the positions. Would it be fair to say that these were adverse findings that were made against you, irrespective of how you wanted to categorize as the prime, or who you wanted to categorize as the primary target of the report?
Yes, through you, Chair. These are very, very serious allegations.
And how did that impact on you?
Well, I'll have to go back a bit, and that the problems really started towards the end of, towards the latter part of 2014, when I was suspended in SARS, and I finally left SARS. And there were 2 attempts to criminally prosecute me. There was a continuous barrage of smears in the Sunday Times for a long period. And the public protector's reports and findings then come on the tail end of that. So it's been one long a series of attacks from 2014. Well, and it still continues because there's a third report that is current, and the second report, though there is a judgment that stands, public protectors applied for leave to appeal to the Constitutional Court. So it's created turmoil in SARS as an institution. It's created turmoil amongst many staff members of SARS. I think perhaps up to 2,000 people left SARS in that turmoil. And it's caused turmoil, obviously, amongst our friends and family. Thank you.
Now, you joined the application as a co-applicant, and your case was fundamentally premised on 2 points: the absence of special circumstances as foreshadowed in Section 6(9) of the Public Protector Act, and that the Public Protector had failed to obtain evidence and relied on unsubstantiated allegations, ignoring evidence provided by you, resulting in the report being set aside by a full bench as irrational, procedurally unfair, and flawed. At paragraph 132 of the affidavit, it details in summary what you have set out, and that in effect the issue of your qualifications, you had not been asked of this in the Section 7(9) notice with which you had been served. Correct?
Correct?
Right? You right, and then one sees that at paragraph 162 of the judgment, the court details some of the affidavits that I have already referred to earlier on that had been put before the court in its consideration of this matter. And you are the deponent of quite a number of those affidavits.
Yes.
You
it is.
confirm that?
Yes, I can.
And then in paragraph 163, let me take you back. You had previously provided, you had informed the public protector, both Advocate Mkhwebane as well as a predecessor in 2014, who had also received complaints regarding the SARS unit. You had provided them with information, correct?
Correct.
And you pointed out to the court that the predecessor had elected not to further investigate the complaint in relation to the unit, but focused on complaints concerning irregular recruitment.
Yes, it is so.
Right. Right. And if one looks at paragraph 163, then the court refers to a supplementary founding affidavit that you had filed after the final documentation in the Rule 53 record was provided. And in the last line it says, it contained and it confirmed that the documentation that you had provided in 2014 formed part of the record which served before the public protector when she compiled her report. Correct?
Correct.
Right. And if then one goes to paragraph 2, well, let's just see which paragraph I'm on at the moment. Let's go down one. Okay. One then goes to $192. Right?
Yeah.
Of the judgment. And Mr. Pillay, I want you to take the judgment from here, because if you look at your affidavit at paragraphs 8.3 and 8.4, you say that in the course of the public protector's investigations relating to the SARS investigative unit, you gave extensive evidence of the public protector and provided her with comprehensive explanations and relevant documentation. This was all done under oath. The public protector dismissed my evidence out of hand, preferring to rely on untested hearsay and gossip to make her findings. During the subsequent review proceedings, I again detailed evidence, and I provided the evidence on oath of Mr. Johan van Lochenberg, who was the head of the SARS investigated unit at all material times. This evidence was the only evidence provided to the public protector under oath, which dealt directly with the activities of the SARS investigative unit. The public protector dismissed my evidence out of hand as simply being my views and opinions. She did not deal at all with Mr. van Lochenberg's evidence, and we've already heard Mr. van Lochenberg's evidence in that regard, and it wasn't contested that his evidence was not dealt with. You particularly in your affidavit highlight from paragraph 192 of the judgment And perhaps you can share with the committee those paragraphs emphasizing particularly what you wish to highlight. That's at paragraph 192 of the judgment.
Thank you, Chair. So paragraph 192. This is further evidenced in the way the public protector approached Mr. Pillay's evidence in the review application. In her answering affidavit, she adopted a dismissive attitude to what she termed Mr. Pillay's views and dealt almost exclusively with Mr. Gordon's various affidavits. This is clear from the following passage taken verbatim from her answering affidavit. The public protector was not bound by Mr. Pillay's views on affidavit. She considered them but found they were a defense of an indefensible establishment of a spying unit within SARS. So that's paragraph 192. Paragraph 193, she then set out a number of points on which she expressed that she was in disagreement with Mr. Pillay's views and dismissed the entirety of what was deposed by Mr. Pillay in his two affidavits in the following terms. The rogue unit narrative is their coining, which is irrelevant to the public protector. The views of Mr. Pillay on state capture are just that, views. Mr. Pillay did not wish to candidly and openly deal with issues that the public protector was interested in. His response was belligerent and displayed a lack of interest in giving the public protector coherent and straight answers to questions asked. The allegations made by Mr. Pillay were vague and speculative. They were riddled with political narratives totally irrelevant to the specific issues that required the public protector to investigate. Mr. Pillay attacked the investigation and questioned its legitimacy based on his political theories of state capture and false political narratives. I disagreed with Pillay on the legal basis for the establishment of for the spying unit within SARS. His explanation sought to avoid giving credible and straight answers, but windy and verbose. Mr. Pillay waffled about the so-called rogue unit narrative and the capturing of SARS, giving no credible evidence. That's paragraph 193. And then we go to 194. It is important to note that no other party in these proceedings, including the public protector and the EFF, has sought to respond at all to what Mr. van Lochrenberg testified in the affidavit deposed by him. What he says thus stands entirely uncontradicted and unchallenged. The public protector has put up no facts or evidence, either in the report or in affidavits filed in this matter that refutes the evidence provided by Mr. Pillay and in brackets, and now by Mr. van Lochrenberg. All that she has done in her answering affidavit is belabor evidence put up by Mr. Pillay as simply his views and opinions, and that she was not bound by.
Okay.
And then we go to paragraph 195. This evidences the most egregious failure.
Yes, I've noted you. I just want him to finish the sentence.
I'll start again. This evidences the most egregious failure by the public protector to understand and honor the most basic requirements of the office she occupies. It is plain that the public protector has approached this investigation with an unwavering commitment to her own preconceived views and biases. The manner in which the public protector had and continued to simply ignore Mr. Pillay's evidence clearly demonstrates her manifest bias. We will return to the issue of bias herein below. Full stop.
Thank you. Just pause there, Mr. Pillay. Advocate Mbofu.
Sorry. Thank you, Chair. Yeah. Okay. No, sorry. I didn't want to disturb Mr. Pillay. But Chairperson, really, this is a mighty waste of our time. We can't have a situation where Ms. Bauer brings a judgment, she reads it, then Mr. Pillay reads the same judgment, and we read the judgment yesterday, and we're going to read it again tomorrow for ourselves. I mean, for what practical purpose is that? Apart from the fact that the judgment is an opinion of a court. So if we're going to have a witness here simply to repeat and reread the judgment as if we can read for ourselves, then what's the point of all this?
Okay, I get your question. Thank you, Advocate Bauer.
I would have thought the judgment is binding on everybody and we can have that debate later. Mr. Pillay wished to emphasize certain parts of the judgment and he's doing so. He's entitled to give his evidence as he wants to. When we spend 45 minutes on other stuff, then we don't bother about wasting the committee's time.
So,
No, I've not recognized you, Advocate Mbofu.
sorry, Chair.
I want us to proceed. You've just asked a question. The purpose for doing this, it's been explained, and I want us to leave it there and proceed with Mr. Pillay.
So you accept that that's what we must do in this committee. We'll just read judgments. But
That's not what. No,
that's what you're saying. You say we must proceed on that basis.
Yeah, no, that's not what we're doing. There's an emphasis on certain paragraphs. So I think, please, let's hold back, Advocate Mbofu.
No, Chair, I'm sorry, Chair. Without any disrespect, Chair, I really need, because I don't know where this is going to end. We have 500 pages of this thing. And I'm just if you or Ms. Bauer can tell us what is the value or purpose of what has just happened in the last 10 minutes of reading a judgment that we've all read without even saying anything about it. Can't we read? And then just allow it on the basis that because there was an objection earlier, and therefore we must have our time wasted. I mean, that's even more ridiculous.
Thank you, Advocate Mbofu. You have your point recorded, and the point being made is that Advocate Bauer wants to make certain emphasis, and he's leading the witness in that regard. Advocate Bauer?
Can I suggest that if I ask my colleague I would get done a lot quicker if we can just refrain from the constant interruptions.
Thank you. Mr. Pillay?
No, this is not an interruption. I'm raising a point. Why do you call it an interruption? I'm raising a point about wasting our time. I'm not going to sit here and listen to 500 pages of reading.
Advocate, I don't appreciate you just without even recognizing the chair. I do not appreciate that.
I'm sorry.
Please.
I'm sorry.
Advocate Bauer?
Mr. Pillay, and it was those findings in the judgment which you sought to highlight this committee. Is that correct?
Yes, there are a few more paragraphs, but I'm in your hands.
I'm going to take you to the few more paragraphs that you want to highlight to the committee, Mr. Pillay, in that regard. If you go further in your affidavit, the High Court, you say in your affidavit that the High Court reflected on the manner in which the public protector had assailed your dignity, firstly by irrationally finding that you were unqualified to be appointed as a Deputy Commissioner of SARS, and second, by going to the extreme or even denying you your matric certificate in her campaign to impugn your dignity. Now, can we just, in dealing with the matric certificate, can you we just take it back for a second, and we don't have to go to the judgment to do that, but the judgment There was a complaint made against you.
Chairperson?
Your hand is not raised.
Oh, I'm sorry, Chair. I'm just trying to be helpful here. No, I was saying, Chair, just to be helpful so that we don't have this toing and froing and wasting more time. On the basis of what was proposed by Honorable Heron, I want to place on record that we admit that what is typed here in this judgment is there, and all other judgments.
Thank you. Thank you, Advocate Mpofu. Advocate Bauer?
Mr. Mpofu, I understood from the start of the proceedings that you also admitted that the contents of what is contained in the affidavits of Advocate Mkhwebane are also what they purport to be in the affidavits. Am I correct?
Am I under cross-examination? No, I'm not. I didn't even hear the question. I was just placing something on record. You can ask me offline, whatever you want to ask me.
But why, Mr. Mpofu, do I need to go offline to do that? The affidavits are under oath, and I'm assuming we're not going to have a debate about the correctness of the affidavits.
No, I don't know what you're talking about. I was just placing something on record about this witness. So whatever else you want to raise about other affidavits, we'll deal with it when we deal with it. I don't even understand the question. I was just trying to avoid interrupting this witness by reading of judgments. I'm saying we admit the judgment is there and it was given by the court, and it's what is typed is what is typed.
And do you admit to the accuracy of the judgment, Mr. Mpofu?
The person I'm not, I don't know. What are you talking about? How can I admit to something that's so blatantly wrong? All these judgments are wrong, factually and otherwise. They say, one of them says that the public protector said she didn't read the IGI report, which she never did, which is not true. How can I admit something that's not true? And one of them says that she said she referred the vulnerability of the Reserve Bank, and your witness said it was his. Must I admit all that fake news?
Thank you, Advocate Mpofu. Thank you, Advocate Mpofu. Advocate Bauer, I want you to proceed with leading the evidence. Advocate Bauer, kindly want you to proceed with leading the evidence.
Thank you. If one goes to the judgment at paragraph 134, and we don't need to go there, there was a complaint made against you that in paragraph 7 of the subpoena, and the court notes that the issue of your qualifications was not raised in the subpoena issued to you, but raised in the subpoena issued to Mr. Gordon.
Yes, it is so.
And at the time the report was released, the public protector knew that you had a matric certificate.
Yes, that's true.
In paragraph 235 of the judgment, there are the contentions in Advocate Mkhwebane's affidavit and the submissions made on behalf of the public protector was that the public protector had made no finding that you had no matric and that you had not provided the information about your qualifications when you were asked to do so. In fact, paragraph 235 of the judgment, could you put it up again? Which one will see from it's also in your affidavit.
Yes, I have. Do you want me to read it?
Yes, please, Mr. Pillay. Just confirm it.
I confirm it. The contention in the answering affidavit and submissions made on behalf of the public protector and the public and made no finding that Mr. Pillay had no metric and that Mr. Pillay did not provide the information about his qualifications when he was asked to do so is disingenuous. Firstly, the conclusion that Mr. Pillay had no degree and no metric was central to the public protector's finding that Mr. Pillay was not qualified to be appointed as the Deputy Commissioner of SARS. Secondly, it is an indisputable fact that Mr. Pillay made a full and accurate disclosure of the extent of his academic qualifications as at the time when he joined SARS, when he testified under oath to the public protector on the 24th of March 2019. Thirdly, in the subpoena which was delivered to Mr. Pillay by the public protector on the 10th of April 2019, Mr. Pillay was called upon to respond to 12 complaints. Notably, Mr. Pillay was not required in the subpoena to deal or to provide any information whatsoever on his qualifications. And then the last paragraph 236. Accordingly, at the time of the report, the public protector well knew that Mr. Pillay had a metric certificate. A conclusion in the report that Mr. Pillay does not hold even the basic qualification, notwithstanding the fact that on 25th March 2019, she accepted that this was a matter of public record and was within her knowledge, is astounding. In doing this, she has manifested clear bias against Mr. Pillay and material irrationality in arriving at her findings. In her answering affidavit, the public protector has put up no evidence supporting her findings in this regard. We submit this further demonstrates that the public protector closed her mind and adopted a process of irrational reasoning. Thank you.
Mr. Pillay, to your recollection, did you have a meeting with Advocate Mkhwebane at which your qualifications was discussed?
Yes, I do recollect the meeting.
And did you confirm with her that you had passed matric as your highest qualification?
Yes, I did.
Now, the court concluded that there was no requirement that only a holder of a degree could be appointed as a Deputy Commissioner of SARS or hold an acting appointment as a commissioner.
Yes. At that time.
Would you have regarded, would you have regarded that to have been the end of the matter?
Yes, I would have regarded it to be the end of the matter.
And was it the end of the matter? I mean, I'm sorry, I'm phrasing it badly. The matter, despite the court's findings, went through several courts of appeal and is still pending.
Yes, the matter is, there is a judgment, but the matter is still pending.
Now, in respect of that issue, you have we've dealt with that. You say in paragraph 10 of the affidavit that you have been embroiled in endless litigation with the public protector for several years now. Have you recently, having obtained finality in the judgment from the Constitutional Court. Has your attorneys prepared bills of costs?
I spoke to them last night. They are preparing the documentation, and they indicated to me it's in the region of about 4 million rands.
And those are the untaxed bills of costs, and correct?
Correct.
And those are the costs that would still have to be recovered from in relation to the court orders
Yes.
that have been issued. And you accept from that would be deducted any cost orders that had been made against you in the proceedings in relation to the interlocutory matters. Now, in the context of the report in the OIG matter, you had pertinently raised this in the affidavit that you had filed in the proceedings before the High Court. Isn't that correct?
It is correct.
And I'm sorry, Mr. Pillay, I'm trying to find the reference to make it easier.
We'll, at this point, take a 15-minute tea break. We'll be back at 12. We'll pause for tea break. Thank you. At 11. I have 12
Recording
in my mind.
stopped.
Yeah, we'll
It's
proceed
now
with our virtual.
11.